You're listening to the Intrepid radio program with Scotty Roberts. Intelligent talk.
Well, folks, welcome to the Friday night Intrepid radio program. This is Scotty Roberts, your host. You're listening via Odyssey Radio Network. That's ODYSY1.com. You can also come on over to my YouTube channel and see the simulcast video stream, and that's at youtube.com/Mr. Scotty Roberts. And you can, while there, join the live chat room with the other Intrep heads. It's starting up already. So come on over, join the chat, join the club, kind of, so to speak, and be part of the family. So thanks for being here tonight. It's Friday. It's the end of the week. My weeks are going by like moments these days. It just seems that we said, hey, it's Friday, but that was a week ago. And so, I don't know, maybe it's the older I'm getting, the faster time goes by, or something like that. Or maybe I'm just having too much fun, time flies when you're having fun. So tonight, now that it's Friday, end of the week, let's wrap up the week. But before we do, I want to show you something. I hadn't planned to do this, so let me get in there. It just hit me because I don't usually do it. First of all, I want to do just a shout out for my good friend John Penman of Penman Hats. You can see all my hats hanging up here. This is what John does. He was a disabled firefighter about 15 years ago, and was really into the Indiana Jones and the hats and all of that. And he started by making the Indiana Jones hat, and he learned that skill, that exacting screen precision, by talking to some of the old guys that made the hats for the movies, that were old hat ears. And that's where he really started off, and he started doing other hats along the way. And one of my favorite hats is that one hanging right there over Sennenmut. That's my first hat I ever got from Penman. It's my replica of Humphrey Bogart's hat from Casablanca. And it's actually called the Casablanca. Now, it hangs there because it's traveled so much around the world with me that I wore a hole in the tip of the crown because I was putting it on and off wrong. You don't grab a hat here, you grab it by the brim. And so now it's retired and it's hanging there. One of these days I'll replace that. But I've got other hats, too, from him. I may one of these days have to get an Indiana Jones hat. But if you're looking for a good hat for yourself, for your man, for a woman, go to Penman Hats. Penman Hats, Penman hats.com. You can find him on Facebook as well. He's got a huge presence there. And you can see the hats that he makes. He makes his more, let's just call it what it is, a more expensive hat. It's a little finer hat. And he also makes his line called the Everyman hat, which is kind of prefabricated, and then he puts all the finishing touches on it. And he does everything from scratch otherwise, and it's a gorgeous hat. This is one of his Everyman hats you can see here. And so he does a fantastic job. So if you want a good hat for you or somebody you know, go on over to Penman Hats and check him out. He's a good friend of mine, and he will not steer you wrong. Also, if you want to find some good garments, I design all my own shirts. We've got the Intrepid radio shirt. We've got all different kinds of shirts for the different things we've done on this show. You can find that over at my Etsy page. And that's etsy.com/shop/Mr. Scotty Roberts. Nope, back that up. Etsy.com/shop/Son of a Patriot. That's my Etsy page. So there's all my personal stuff out of the way. Those are my ads. And I appreciate your patronizing my advertisers and my sponsors, as well as my page. So let's get on with it now. We started talking yesterday about a topic I didn't know much about. until I saw it not long ago and started reading up a bit about it, and that is about this missing 13th Amendment. Now, the missing 13th Amendment. Now, we all know what the Constitution is. We all know that it has amendments that were made to the Constitution. And there was a missing amendment, and it's something about no lawyers allowed in public office. We started talking about this yesterday and laying the background for this. Now, this is pretty heavy-duty historical content, and it can be a little confusing and a little deep and complex to dig into. But what I'd like to have you do is kind of put on your thinking caps and think your way through this with me. We got, I don't think even halfway through the information I have here, but this is really what we're presenting is this covert plot that altered the U.S. Constitution. And it has been exposed by a couple of people who stumbled accidentally across old copies of the Constitution that had this 13th Amendment in it that is different than what we have today. And it was in printed copies from the 1800s. And so they started looking into it, and they uncovered a conspiracy to subvert the American Republic. And it's regarding the 13th Amendment and the missing elements of the 13th Amendment. And so we got all the way yesterday into saying in order to amend the Constitution, you have to have a proposal that goes, and then it has to be ratified by all the states. And we found at the time it needed to be ratified in 1810 by 13 states. And only 12 are listed in the ratification process. The Constitution requires 3/4 of the states to ratify a proposed amendment before it can be added to the Constitution. And the founders were genius in that they made it a very difficult process to amend the Constitution. That prevented the constitutional amendments that were willy-nilly or silly or not thought through or on the whim of a change. You can't change the Constitution on those bases. And so they made it a very difficult process. And the Constitution, in requiring this 3/4 proposed amendment, proposed the title of nobility amendment in 1810. And there were states, 13 of which had to ratify it for the amendment to be adopted. Now, according to the National Archives, there was a list of 12 states that ratified this, and they needed one more. But before a 13th state could ratify it, the War of 1812 broke out. That's when the British reattacked the United States. I don't know how many people are even as familiar with that. After they lost the Revolution in, I think it was 1782 was the year of the surrender of Britain to the United States. After that, now we've got, about 14 and... What's 14 and 18? You got 32 years went by, and Britain reattacked the United States. That's the War of 1812 in a nutshell. And by the time the war ended in 1814, the British had burned the capital of the United States. They burned the Library of Congress down, and most of the records of the first 38 years of government. And whether there was a connection between the proposed title of nobility amendment and the War of 1812 isn't really known. However, the momentum to ratify the processed amendment was lost in the tumult of the War of 1812. Then 4 years later, on December 31st of 1817, the House of Representatives resolved that President Monroe inquire into the status of this 13th Amendment. In a letter dated February 6th of 1818, President Monroe reported to the House that the Secretary of State, Adams, had written to the governors of Virginia, South Carolina, and Connecticut to tell them that the proposed amendment had been ratified by 12 states and rejected by 2, New York and Rhode Island, and asked the governors to notify him of their legislature's position. Now, the House document number 76, this and other letters written by the President and the Secretary of State during the month of February 1818 note only that the proposed amendment had not yet been ratified. However, those letters would later become crucial because, in the absence of additional information, they would be interpreted to mean the amendment was never fully ratified. And on February 28th of 1818, Secretary of State Adams reported the rejection of the amendment by South Carolina. That's House Document 129. And there are no further entries regarding the ratification of the 13th Amendment in the Journals of Congress. Whether Virginia ratified is neither confirmed nor denied. Likewise, a search through the executive papers of Governor Preston of Virginia doesn't reveal any correspondence from Secretary of State Adams. However, there is a journal entry in the Virginia House that the governor presented the House with an official letter and documents from Washington, D.C., within a time frame that conceivably includes receipts of Adams' letter. Now, again, no evidence of ratification, but there was also none of denial. Now, on March 10th of 1819, that's 200 years ago, 201 years ago, the Virginia legislature passed Act Number 280, the Virginia Archives of Richmond. It's a miscellaneous file. And it states this, be it enacted by the General Assembly that there shall be published an edition of the laws of the Commonwealth, in which shall be contained the following matters, that is to say, the Constitution of the United States and the amendments thereto. This act was the specific legislated instruction on what was, by law, to be included in the republication, a special edition of the Virginia Civil Code. And the Virginia legislature had already agreed that all acts were to go into effect on the same day, the day the act to republish the Civil Code was enacted. Therefore, the 13th Amendment's official date of ratification would be the date of the republication of the Virginia Civil Code, which would be March 12th of 1819. Now, the delegates knew that Virginia was the last of the 13 states that were necessary for the ratification of this 13th Amendment. They also knew that there were powerful forces allied against this ratification, so they took extraordinary measures to make sure that it was published in sufficient quantity. 4,000 copies were ordered, almost triple their usual order, and instructed the printer to send a copy to President James Monroe as well as James Madison and Thomas Jefferson. The printer, Thomas Ritchie, was bonded. He was required to be extremely accurate in his research and his printing, or he would forfeit his bond. Now, in this fashion, Virginia announced the ratification by publication and dissemination of the 13th Amendment of the Constitution. And there is question as to whether Virginia ever formally notified the Secretary of State that they had ratified this 13th Amendment. Some have argued that such notification was not received, or at least not recorded. And the amendment was therefore not legally ratified. However, printing by a legislature is prima facie evidence of ratification. Further, there's no constitutional requirement that the Secretary of State or anyone else be officially notified to complete the ratification process. So the Constitution only requires that 3/4 of the states ratify an amendment to be added to the Constitution. If 3/4 of the states ratify, the amendment is passed. Period. The Constitution is otherwise silent on what procedures should be used to announce, confirm, or communicate the ratification of amendments. Now, I'm pretty sure you can hear that screaming going on in the background, whether you're on the radio or you are watching this show on YouTube. That is my smallest child. That is Ellery, the 5-year-old queen, self-appointed, self-acknowledged queen of the universe. Now, they know when Dad is in doing a show that they aren't supposed to do that. She does her own thing. I've gotten to the point where I think one of these days I'm going to have to remove a limb to make my point. That when there's a rule, you have to abide by it. So, now, let's move back on. Knowing that the last state necessary to ratify the amendment, the Virginians had every right to announce their own and the nation's ratification of the amendment by publishing it on a special edition of the Constitution. So they did. And word of Virginia's 1819 ratification spread throughout the states, and both Rhode Island and Kentucky published the new amendment in 1822. And Ohio first published it in 1824. Maine ordered 10,000 copies of the Constitution, with the 13th Amendment to be printed for use in schools in 1825, and again in 1831 for their census edition. Indiana revised laws of 1831, published the 13th article to the Constitution on page 20 of the Northwest Territories, published in 1833. Ohio published it in 1831 and 1833. Then came the Wisconsin Territory in 1839, the Iowa Territory in 1843, Ohio again in 1848, Kansas statutes in 1855, and Nebraska Territory 6 times in a row from 1855 to 1860. So far, David Dodge, the guy who has been writing and researching all about this thing for years, has identified 11 different states or territories that printed the amendment in 20 separate publications over 41 years in the early 1800s. And more editions, including this 13th Amendment, are sure to be discovered. Dodge was onto something with his research. So this fully ratified 13th Amendment was published for all those different times in all those different publications. And you might be able to convince some of the people, or maybe even all of them for a little while, that this 13th Amendment was never ratified. Maybe you can show them that the 10 legislatures which ordered it, published 18 times, we've discovered so far, consisted of ignorant politicians who don't know their amendments from their articles. And you might even be able to convince the public that our U.S. forefathers never meant to outlaw public servants who pushed people around, accepted bribes or special favors to look the other way. Maybe you could prove all that for a time. But before you do, there's an awful lot of evidence to be explained. Now, the amendment just disappears. In 1829, this note appeared on page 23, volume 1 of the New York Revised Statutes. It said this: "In the edition of the laws of the U.S. before referred to, there is an amendment printed as Article 13, prohibiting citizens from accepting titles of nobility or honor, or presents, offices, etc., from foreign nations. But by a message of the President of the United States of the 4th February, 1818, in answer to a resolution of the House of Representatives, it appears that this amendment has been ratified only by 12 states, and therefore has not been adopted." And it gives a reference telling you to go check this out here. And, excuse me, and therefore has not been adopted. Both notes refer to the laws of the United States, by the way, in what they stated here in Oregon. Now, it's not yet clear whether the 13th Amendment was published in Laws of the United States, first volume, prematurely, by accident, in anticipation of Virginia's ratification, or as part of a plot to discredit the amendment by making it appear that only 12 states had ratified. Now, whether the Laws of the United States, volume 1, carrying the 13th Amendment, was recalled or made up is unknown. In fact, it's not even clear that the specified volumes were actually printed. The law library of the Library of Congress has no record of its existence. Now, because the noted authors reported no further reference to the 13th Amendment after the President's letter of February of 1818, they apparently assumed the ratification process had ended in failure at that time. If so, they neglected to seek information on the amendment after 1818, or at the state level, and therefore missed evidence of Virginia's ratification. Now, this opinion, assuming that the President's letter of 1818 was the last word on the amendment, has persisted to this day. Now, in 1849, Virginia decided to revise the 1819 Civil Code of Virginia, which had contained the 13th Amendment for 30 years. It was at that time that one of the code's revisers, a lawyer named Patton, wrote to the Secretary of the Navy, William B. Preston, asking if this amendment had actually been ratified or appeared by mistake. Preston wrote to J.M. Clayton, the Secretary of State, who replied that his amendment was not ratified by a sufficient number of states. This conclusion was based upon the information that the Secretary of State, John Quincy Adams, had provided the House of Representatives in 1818 before Virginia's ratification in 1819. Even today, the Congressional Research Service tells anyone asking about this 13th Amendment this same story, that only 12 states, not the requisite 13, had ratified it. So, the official word is that it was never ratified. However, despite Clayton's opinion, the amendment continued to be published in various states and territories for at least another 11 years. The last known publication was in the Nebraska Territory in 1860. Once again, the 13th Amendment was caught in the riptides of American politics. South Carolina seceded from the Union in December of 1860, signaling the onset of the Civil War, and in March of 1861, President Abraham Lincoln was inaugurated. Now, later in 1861, another proposed amendment, also numbered 13, was signed by President Lincoln. This was the only proposed amendment that was ever signed by a president. That resolve to amend read this: Article 13. No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or services by the laws of said state. In other words, President Lincoln had signed a resolve that would have permitted slavery and upheld the state's rights. Only one state, Illinois, ratified this proposed amendment before the Civil War broke out in 1861. So in the tumult of 1865, the original 13th Amendment was finally removed from the U.S. Constitution. So on January 31st, another 13th Amendment, which prohibited slavery in Section 1 and ended states' rights in Section 2, was proposed. And on April 9th, the Civil War ended with General Lee's surrender. So on April 14th, President Lincoln, who in 1861 had signed the proposed amendment that would have allowed slavery and states' rights, was assassinated. On December 6th, the new 13th Amendment, loudly prohibiting slavery and quietly surrendering states' rights to the federal government, was ratified, replacing and effectively erasing the original 13th Amendment that had prohibited titles of nobility and honor. And if that's not confusing enough, there's more to come. Stay tuned during this break. We'll be back in a couple of minutes and pick this up right where we left off.
Are you looking for a really awesome and amazing graphic designer? How about an illustrator or a photographer? This is Rainey Roberts, and I wanted to tell you how you can get my designer, illustrator husband, Scotty Roberts, to work for you on your project. Do you have an awesome self-published book but no cover, or even worse, a cover that really sucks? Do you need a kick-ass logo for your company or some f***ing awesome graphic designs for your ads or website? Then get in touch with my husband for the best f***ing awesome kick-ass design and illustration. He knows his stuff, and he's been at this for more years than I've been alive. Go to ScottAllenRoberts.com. That's Scott with 2 T's, ALANROBERTS.com to take a look at his online portfolio of work, or call 651-468-8115. Now go out and kick some ass with some kick-ass graphic design.
Hire my dad so he can take me to Disneyland.
All right, gang, thanks for sitting on through that break. This is Scotty Roberts. You're listening to the Intrepid radio program, the exciting Intrepid radio program. We're talking about American history. You're listening at Odyssey Radio, ODYSY1.com. You're also joining us via video at the simulcast over on my YouTube channel at youtube.com/Mr. Scotty Roberts. You can join the chat room if you're not already there. You can share your views on this, talk amongst each other and the other Intrepheads and the family we have over there, and enjoy this show. This is heavy history we're digging into. It is not a conspiracy theory. It is, however, dealing with a conspiracy, dealing with a covert movement to have done away with a certain amendment that was, for all practical purposes, denied. We're going to look into this even a little bit more because there's more to this than that. Now, we left off talking about, it seems that the 13th Amendment in its original form was ratified by only 12 states. The question of Virginia having ratified it was always up in the air because of the War of 1812. And by the time we hit the Civil War, pre-Civil War, Abraham Lincoln had signed a new version of Amendment 13 that had nothing to do with the honors and the emoluments and the accepting titles of nobility and royalty and things like that from other countries, which also had in it this idea of honors that had to do with lawyers and esquires and so on, serving in public office. Now, we've got this new 13th Amendment prohibited, the old 13th Amendment, its original language, prohibited the titles of nobility. Now, there's a significance of removal here. And to create the present oligarchy, a rule by lawyers in which the U.S. now endures, the lawyers first had to remove the 13th, by the way, I meant in its day, back in the 1860s now. The lawyers first had to remove the 13th titles of nobility. The amendment might otherwise have kept them in check. In fact, it was not until after the Civil War and after the disappearance of this 13th Amendment that the American bar associations began to appear and exercise political power. Now remember, in this original 13th, this whole idea of honors in context to colonial America becoming the United States according to the language of the day, this was to prevent lawyers and attorneys and bar associations from people who were part of any of those or were lawyers or were attorneys from holding public office because of the special interests involved. What do we have in our Congress today? What do we have all throughout our government? Riddled with attorneys and lawyers. Because, according to what they could find, the 13th Amendment had never been fully ratified. And there's a controversy here. Now, since the unlawful deletion of the 13th Amendment, the newly developing bar associations, lawyers, began working diligently to create a system wherein lawyers took on a title of privilege and nobility as esquires and received the honor of offices and positions like district attorneys or judges, and that only they could hold. And by virtue of these titles, these honors, these special privileges, lawyers have assumed political and economic advantages over the majority of the United States citizens. And through these privileges, they've nearly established a two-tiered citizenship in this nation, where a majority might vote, but only a minority, lawyers, may run for political office. So this two-tiered citizenship is clearly contrary to Americans' political interests and the nation's economic welfare and the Constitution's egalitarian spirit. So the significance of the missing 13th Amendment and its deletion from the Constitution is this. Since the amendment was never lawfully nullified, it's still in full force and effect, and it's the law of the land. If public support could be reawakened on this missing amendment might provide a legal basis to challenge many existing laws and court decisions previously made by lawyers who were unconstitutionally elected or appointed to their positions of power. It might even mean the removal of lawyers from the current U.S. governmental system. Can you imagine that? What if we, like Shakespeare said, first let's kill all the lawyers? It's out of context, but it was in one of his plays. So at the very least, this missing 13th Amendment demonstrates that 2 centuries ago, lawyers were recognized as enemies of the people and of the nation. And some things will never change. Imagine if we were to find that this law is valid, this constitutional law was valid, and we had to remove every lawyer from public office. It's mind-boggling. Now, and remember, they had a reason that they wanted lawyers excluded from serving in public office. Now, for those who cannot recall history, heed warnings of the four founding fathers. In his farewell address, George Washington warned of, quote, change by usurpation, for through this, in one instance, may be the instrument of good. It is the customary weapon by which free governments are destroyed. Usurpation of the law is the tool that is used to change governments. It's the tools by which free governments are destroyed. Look what's going on in our nation right now. Usurpation destroys free governments. In 1788, Thomas Jefferson proposed that we have a Declaration of Rights, similar to Virginians. 3 of his suggestions were freedom of commerce against monopolies, trial by jury in all cases, and no suspensions of habeas corpus. Now, no doubt, Washington's warning and Jefferson's ideas were absolutely dismissed as redundant by those who knew the law. Who would have dreamed the U.S. legal system would become a monopoly against freedom when that was one of the primary causes for the rebellion against King George III? Yet the denial of trial by jury is now commonplace in the United States courts, and habeas corpus for crimes against the state, and it's suspended in those cases. By crimes against the state, I'm referring to political crimes, where there's no injured party and the corpus delicti, the evidence, the physical evidence, the corpus delicti, is equally imaginary. So the authority to create monopolies was judge-made law by Supreme Court Justice John Marshall, and all during the early 1800s. The judges and the lawyers granted to themselves the power to declare the acts of the people unconstitutional. And they waited until their decision was grandfathered and then granted themselves a monopoly by creating the bar associations. And although the Article 6 of the U.S. Constitution mandates that the executive orders and treaties are binding upon the states, and it says, and the judges in every state shall be bound thereby, anything in the Constitution or laws of the state of the country notwithstanding, the Supreme Court has held that the Bill of Rights, not binding upon the states, and thereby resurrected many of the complaints enumerated in the Declaration of Independence, exactly as Thomas Jefferson foresaw in his Notes on the State of Virginia that he wrote in 1784. Now, our rulers will become corrupt, he said, our people careless. The time for fixing every essential right on the legal basis is now, while our rulers are honest and ourselves united. From the conclusion of this war, we shall be going downhill. It will not then be necessary to resort every moment to the people for support. They will be forgotten, therefore, and their rights disregarded. They will forget themselves, but in the sole faculty of making money, and will never think of uniting to effect a due respect for their rights. The shackles, therefore, which shall not be knocked off at the conclusion of this war, will remain on us as long, will be made heavier and heavier, till our rights shall receive or expire in a convulsion. Now we await the inevitable convulsion. Only two questions remain. Will we fight to revive our rights, or will we meekly submit as our last remaining rights expire, surrendering to the courts and perhaps to a new world order? That's a big question that's on our plate now, and a lot of this hinges on whether or not the 13th Amendment is actually law. So there were more editions found of this, by the way. There was a researcher in Indiana and another in Dallas who found 5 more editions of the statutes that include the Constitution and the missing 13th Amendment. These editions were printed by Ohio in 1819. Connecticut, one of the states that voted against ratifying the amendment in its original form, in 1835. Kansas in 1861, and the Colorado Territory in 1865 and 1867. And these finds are very important because they offer independent confirmation of the claims that are being made in this whole cover-up of the 13th Amendment. And they extend the known dates of publication from Nebraska 1860 and Colorado in 1867, before and after the Civil War. Now, the most intriguing discovery was the 1867 Colorado Territory edition, which includes both the missing 13th Amendment and the current 13th Amendment, freeing the slaves, on the same page. The current 13th Amendment is listed as the 14th Amendment in the 1867 Colorado edition. Now, this investigation has followed a labyrinthine path that started with the questions about how the U.S. courts evolved from a temple of the Bill of Rights to the current Star Chamber, and whether this situation had anything to do with retiring Chief Justice Burger's warning that we were about to lose our Constitution. Now, the 7-year investigation into this had been fruitful beyond belief, and the information on the missing 13th Amendment is only a drop in the bucket of the information that was discovered. Still, the research continues, and by definition is never truly complete. Now, the arguments on this. Imagine a nation which prohibited at least some lawyers from serving in government. Imagine a government prohibited from writing laws granting honors or special privileges, immunities, or advantages to individuals, groups, or government officials. Imagine a government that could only write laws that applied to everyone, even themselves, equally. It's never been done before, not once, but it's been tried. In 1810, the Congress of the United States proposed a 13th Amendment to the Constitution that might have given us just that sort of equality and political paradise. The story begins again in 1983, when David Dodge and Tom Dunn discovered an 1825 edition of the Maine Civil Code, which contained the U.S. Constitution and a 13th Amendment which no longer appears on the Constitution. And it states, "If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without the consent of Congress accept and retain any present, pension, office, or emolument of any kind whatsoever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them or either of them. That was the amendment. This amendment would have restricted at least some lawyers from serving in government, and would prohibit legislatures from passing any special interest legislation, tax breaks, special immunities for anyone, not even for themselves. And it might have guaranteed a level of political equality in this nation that most people can't even imagine. So since 1983, researchers have uncovered this evidence that, 1, the 13th Amendment prohibiting titles of nobility and honors, which we described yesterday, which basically talks about attorneys, appeared in at least 30 editions of the U.S. Constitution of the United States, which were printed by at least 14 states or territories between 1819 and 1867. And this amendment quietly disappeared from the Constitution near the end of the Civil War. So either this amendment was unratified and mistakenly published for almost 50 years, or ratified in 1890 and then illegally removed from the Constitution by 1867. If this 13th Amendment was unratified and mistakenly published, the stories remained unnoticed in American history for over a century. Now, if so, it's at least a good story and an extraordinary historical anecdote. On the other hand, folks, if these guys are right in their research, and the amendment was truly ratified, an amendment has been subverted from our Constitution. If so, this missing amendment would still be the law. And this story could be one of the most important stories in American history. So whatever the answer, it's certain that something extraordinary happened to our Constitution between 1819 and 1867. And so there's pros and cons in all of this for the ratification. Of course, there's two sides to the issue. The guys researching this, the principal researchers, argued that this 13th Amendment was ratified in 1819 and then subverted from the Constitution near the end of the Civil War. U.S. Senator George Mitchell of Maine and Mr. Dane Hartgrove, the acting assistant chief, the civil reference branch of the National Archives, have argued that the amendment was never properly ratified and only published in error 50 times. And there's some agreement there. Both sides agree the amendment was proposed by Congress in 1810. Both sides also agree that the proposed amendment required the support of at least 13 states to be ratified. Both sides agree that between 1810 and 1812, that 12 states voted to support ratification. The pivotal issue is whether Virginia ratified or rejected the proposed amendment. Dodge contends that Virginia voted to support the amendment in 1819. And so the amendment was truly ratified and should still be a part of our Constitution today, now. Senator Mitchell and Mr. Hartgrove disagree, arguing that Virginia did not ratify. Unfortunately, several decades of Virginia's legislative journals were misplaced or destroyed, possibly during the Civil War, possibly during the 1930s. Consequently, neither side has found absolute proof that the Virginia legislature voted for or against ratification. And so a series of letters exchanged in 1991 between the main researcher, David Dodge, Senator Mitchell, and Mr. Hartgrove illuminate the various points of disagreement. After Dodge's initial report of a missing amendment in the 1825 Maine Civil Code, Senator Mitchell explained that this addition was a one-time publishing error. The Maine legislature, he said, quote, "The Maine state of Maine's legislature mistakenly printed the proposed amendment in the Maine Constitution as having been adopted. As you know, this was a mistake, and as it was not ratified. So further, all additions to the Maine Constitution printed after 1820 exclude the proposed amendment, and only the originals contain this error." Now, Dodge dug a little bit deeper. He found other additions. There are 30 to date of state and territorial civil codes that contained the missing amendment, and thereby demonstrated that the Maine publication was not a one-time error at all. So, you could say, yes, Virginia, there is a ratification. So after examining Dodge's evidence of multiple publications of the missing amendment, Senator Mitchell and Mr. Hartgrove conceded the amendment had been published by several states and was ratified by 12 of the 17 states of the Union in 1810. However, because the Constitution requires that 3/4 of the states vote to ratify an amendment, Mitchell and Hartgrove insisted that the 13th Amendment was published in error, a one-time error, in Maine, because it was passed by only 12, not 13 states. Now, Dodge investigated which 17 states at the time were in the Union at the time the amendment was proposed, which states had ratified, which states had rejected the amendment, and determined that the issue hung on whether one last state, Virginia, had or had not voted to ratify the 13th Amendment. So after several years of searching the Virginia State Archive, Dodge made a crucial discovery. In spring, now this is important, folks, in spring of 1991, Dodge found a misplaced copy of the 1819 Virginia Civil Code, which included the missing 13th Amendment. Dodge notes that, curiously, there was no public record that shows this book, the 1819 Virginia Civil Code, exists. It's not cataloged as a holding of the Library of Congress, nor is it in the National Union Catalog. Neither the State Law Library nor the law school in Portland were able to find any trace that this book exists in any of their computer programs. So Dodge sent photocopies of the 1819 Virginia Civil Code to Senator Mitchell and Mr. Hartgrove and explained that under legislative construction, it's considered prima facie evidence that what is published as the official acts of the legislature are the official acts. So by publishing the amendment as ratified in an official publication, Virginia demonstrated that they knew they were the last state whose vote was necessary to ratify this 13th Amendment. They had voted to ratify the amendment and were publishing the amendment in a special edition of their civil code as an official notice to the world that the amendment had indeed been ratified. Now, Dodge concluded that unless there is compelling evidence to the contrary, it must be held that the Constitution of the United States was officially amended to exclude from its body of citizens any who accepted or claimed a title of nobility or accepted any special favors. Foremost in this category of ex-citizens are bankers and lawyers. It was ratified. Now, undeterred, Senator Mitchell wrote that Article 13 did not receive the 3/4 vote required from the states within the time limit to be ratified. Although his language is imprecise, Senator Mitchell seems to concede that although the amendment had failed to satisfy the time limit, the required 3/4 of the states did vote to ratify. Now, Dodge replied to him, contrary to your assertion, there was no time limit for amendment ratification in 1811. Any time limit is now established by Congress in the resolves for proposed amendments. So, Mitchell tried to get around it by saying, well, it was probably ratified by the 13 states, but they didn't do it in a timely fashion. And Dodge reminded him in 1811 they didn't have that requirement. So in fact, ratification time limits didn't even start until 1917, 100 years later, when Section 3 of the 18th Amendment stated that this article shall be inoperative unless it shall have been ratified within 7 years from the date of submission to the states by Congress. And so a similar time limit is now included on other proposed amendments. But there was no specified time limit when the 13th Amendment was proposed in 1810 or ratified in 1819. So Senator Mitchell remained determined to find some rationale somewhere that would defeat Dodge's persistence. And although Senator Mitchell implicitly conceded that his published by error and time limit arguments were invalid, he continued to grope for reasons to dispute the ratification. So regardless of whether the state of Virginia did ratify the proposed 13th Amendment on March 12th of 1819, this approval would not have been sufficient to amend the Constitution, so said Mitchell, without stating any other reasons. So in 1819, there were 21 states in the United States, and any amendment would have required approval of 16 states to amend the Constitution. So according to your own research, Virginia would have only been the 13th state to approve the proposed amendment. This is what Mitchell wrote to Dodge. And Dodge replied to him, Article 5, Amendment Procedures of the Constitution, is silent on the question of whether or not the framers met 3/4 of the states at the time of the proposed amendment is submitted to the states for ratification, or 3/4 of the states that exist at some future point in time. Since only the existing states were involved in the debate and the vote on Congress on the resolve proposing an amendment, it's reasonable that ratification be limited to those states that took an active part in the amendment process. And you can imagine this went on, and it goes on and on and on. And there's so much more information on this. I would love to be able to get back to this. And because there's at least one more show's worth of stuff on this. And so we'll probably cover this again on Monday. But do you see, there was a 13th Amendment that, in essence, the bottom line, prohibited lawyers from serving in elected offices. And who's fighting this? Lawyers that are in public office. Tells you something right there. So we'll come back to this again and try to wrap it on Monday, as little as I like carrying this over the weekend. And speaking of the weekend, join me here on Sunday morning at 9 a.m. Central Standard Time. It's not going to be on Odyssey Radio. It's only on my YouTube channel for It's Sunday. So you guys have a good weekend. Thanks for listening. I'll see you on Sunday morning.